Hi everyone, I'm Sabrina.
And I'm Jonathan. We are the lawyers at Varity Law.
When we pass, most of our assets will be immediately frozen. We must apply to the court for an approval document to get the assets unfrozen and passed down to our beneficiaries. This process can be very simple or very complicated depending on many factors.
For example, when there's a beneficiary under 18, everything becomes much more difficult and expensive. In Ontario, a minor is only allowed to own $35,000. If their share of an inheritance is more than this, then they must have an adult appointed by the court to manage their money for them until they turn 18. This appointed adult is called a guardian, and the process to select this guardian is called the guardianship application.
Okay, but what about the minor's parents? Shouldn't they just be allowed to manage the child's money without needing to go through with this guardianship application?
That is the case with custody, but not with guardianship. So even if one parent dies, the other parent remains responsible for all decisions related to the child, like medical decisions, or where the child will live. However, there are special laws designed to protect the minor's property, even from their parents. If a parent or someone else wants to have control of a minor's inheritance and it is over $35,000, they must be appointed as the guardian.
Okay, can you give us an example?
Sure. Let's say dad dies, survived by his son and his wife, the mom. The son is only 15 years old when the dad dies, so mom becomes the sole parent who would have custody of their son. She makes all important decisions. However, if the son's share of the inheritance is above $35,000, the mom would still need to apply for guardianship to manage his inheritance.
Okay, so if the son inherits more than $35,000, mom will need to apply to be the son's guardian for property.
Yes. Let's use the previous example again. Let's say the dad listed both his wife and his son as the beneficiaries to his estate, with each entitled to half of the assets. Then, unfortunately, dad passes away before the son reaches 18 years old. Then, mom would need to apply for guardianship to manage the son's share of the dad's estate.
Exactly. Or let's say dad has no will. Then according to estate law, his wife will receive a fixed amount called preferential share. This amount is currently set as $350,000. Then, since dad only has one child, the rest of the estate is split evenly between his wife and his son.
Exactly. So let's say the dad died with an estate worth $1 million. The wife would get the first $350,000, and the remaining $650,000 would be split evenly between the wife and the son. Since the son is getting $325,000, which is much more than $35,000, the wife would need to apply for guardianship so she can be allowed to manage the son's inheritance until he turns 18.
Okay, what if the mom just doesn't want to manage the son's money?
In that case, there is another option. The mom could let the court hold and manage the son's assets until he turns 18. However, when the funds are held with the court, you have no say in how the money gets invested. The court will only choose the safest investments with modest returns. This is why many people would prefer to invest the money themselves because they feel they could get a better return on the investment, and because of this, they apply for guardianship.
Also, sometimes the mom will need to pay for the son's expenses. If she wants to use his share of inheritance to pay for expenses, she must apply to the court each time she wants to use the money. And the court must be convinced that the expense is legitimate before it will release the money to the mom.
Yes, so examples of legitimate expenses for the son would be tuition or medical costs. Those will likely be approved by the court, but shared expenses like utilities or rent would be less likely to get approved. As well, the mom must prove that she cannot afford the son's expenses herself before the court would reimburse her for those.
That is certainly a downside to having court hold and manage the son's inheritance. So let's say mom decided to apply for guardianship to manage the son's money. What is involved in this application?
Well, when someone applies to be the guardian for a minor, the Ontario government pays for the minor to have their own lawyer who will represent the minor and help protect their inheritance. The lawyer will review the application to confirm all estate debts have been paid and that the minor's funds have been protected.
Okay, that makes sense. Would the mom have to provide anything else when applying to be the guardian?
Yes. The court wants to know that the person applying to be the guardian is capable of protecting the minor's inheritance and that they have a plan for it. This will include something called a management plan. The mother will speak to an investment advisor, like the one at her bank, who will prepare an investment plan. The investment plan should be designed to protect and grow the minor's inheritance without exposing it to too much risk. If the plan is too risky, the lawyer assigned by the government will probably oppose you becoming the guardian.
Wow, that sounds very difficult.
It is, but if you hire an experienced estate law firm, the whole process will be taken care of for you.
That's right. The estate law firm can present a convincing application and get the government's lawyer to agree with the management plan.
Exactly. Once the government lawyer confirms that they agree in writing, the application package would be submitted to the court. If the judge agrees with the request to be guardian, they issue an order that the mother is the guardian of the son's property. Now, the mother would be able to go to the bank and manage her son's inheritance and make the investments proposed in the management plan given to the court.
Okay, that does sound complicated. If you don't convince the government lawyer to agree, that will make approval unlikely. That is an important reason to have an experienced lawyer for this process. Is there anything else we should be aware of when it comes to guardianship?
Yes. When someone applies to the court to become the guardian of property, they may be required to get a bond insurance policy, which can cost up to 5% of the value of the estate. The person applying to become the guardian must pay this fee up front. However, if you hire an experienced lawyer, it is possible to either A, get the court to waive the bond policy requirement, or B, get the court to reduce the amount of coverage required for the bond policy, which would reduce the cost.
Oh, that would be a lot of money. Is there anything someone can do to reduce the risk that they will require a bond?
Yes. Having a strong financial management plan is important. Also, being listed in the will as the guardian for the minor's property is incredibly helpful. In our prior example, if the deceased dad named the mom as the guardian for the son, a court is much more likely to waive the bond requirements.
That is really good to know. Now, given how difficult it is to do a guardianship application, is there any way to skip this?
There are really only two ways. One is to deposit the minor's inheritance with the court, which we talked about previously. Or the dad could leave the entire inheritance to the mom and trust that she will manage and give the son's share to him once he turns 18.
But there's a lot of risk to that. There is no one to supervise the mom's actions. So if the will states that the mom gets all the inheritance, no one will intervene if she wastes all the money without leaving anything for the son. So this option is only good if there is a strong trust between dad and mom.
Absolutely. But if there is trust, then having the will is essential. Let's take the same example. The dad completely trusts the mom and intends to leave everything to her. However, he never got around to writing the will. After he passes, according to estate legislation, both mom and son are entitled beneficiaries. As the son is a minor, he cannot just sign away his inheritance rights.
You're right. So this means the son must receive a portion of the inheritance. So guardianship application is mandatory unless the mom let the court manages his share of the inheritance.
This situation is even worse if the mom is not a married spouse of the dad and they are just common law partners. This means, according to estate legislation, the son will get the entire inheritance. If the mom wants to use or manage any part of the inheritance, a guardianship application is mandatory.
All of this can be avoided by having a will stating otherwise. All right, that's all for today. We will see you in our next month's video.